You can see from, okay, got it. Let me respond to this. All right. Yes, this is a cybersecurity and the right of privacy. And as Ms. Bass has indicated, this is basically a realization of what we're going through with the pandemic and the monitoring of employees through many ways, such as workstation monitoring, phone conversations, video surveillance, as well as internet and social media. As she mentioned, this is interactive. We'll talk about that a little later. I do want to give you a bit of background. The Electronic Communications Privacy Act is currently the federal prevailing authority which controls the monitoring of devices in the United States. However, employees certainly have the right to keep some things private and confidential under certain circumstances that we'll go through and that I've outlined in the scenarios. The scenarios develop basically show a variety of sundry situations that are worth analyzing and discussing because this phase of the law is developing. As a matter of fact, as you will see, technology is really ahead of the law in many situations, such in the area of keystroking technology or in the collection of biometrics, that is a thumbprint or facial print, and geolocation monitoring, such as the GPS. The prevailing issue in National Labor Relations Board and labor law is whether or not the employer's surveillance and management practices viewed collectively would tend to interfere or prevent a reasonable employee from engaging in activities under the NLRA, the National Labor Relations Act. That is, should it be required that employees disclose to employees the technologies that are used to monitor the employees or manage them, as well as how employees utilize the information that is obtained. Another concurrent issue is whether or not this collected information that the employers would gather would chill the protected rights of unions. For example, what if the employer's collected information reveals a discussion of certain areas that might be forming a union? What are those protected activities? Well, there certainly are the Section 7 section of NLRA, the right to organize, the right to form, the right to join, the right to assist a labor organization or engage in concerted activities for the purpose of collective bargaining. I've developed 3 scenarios. In each scenario, there are at least 3 or 4 questions. And we would talk about each question after I give the scenario. The first scenario is ABC Company, located in Columbus, Ohio, recently installed monitoring equipment to improve productivity. The monitoring device captures information from employee John Smith's personal email account. It also captures screenshots every 10 minutes, providing the company with information on John's working habits when his computer is on idle status. On August 19th, 2021, John had difficulty logging in. Thus, he called the company's subcontractor to repair this problem. It was repaired, allowing John to log in and continue his work. The monitoring device employed by the company provides a warning that logging in also indicates the employee consents to be monitored. However, this warning was omitted when John's computer was repaired. Employee John, through his union representative, maintains that the company has unfairly gained access to his personal email account, as well as his personal financial information. Specifically, the union advocate asserts that the company has no right to monitor his activity through screenshots. In addition, the union representative also argues that John never gave his consent to be monitored. Thus, the union advocate challenges the company with invasion of privacy when John learned that his email account containing information regarding his private financial investments were seen by the company through screenshots. It was only upon John's excessive idle time that prompted the company to call him into corporate office. It was then that John learned the extent of the company's finances, knowledge of his finances. John also learned that such information was continuously collected by the company while monitoring his idle time. Now, question 1, will employee John prevail on the issue of not giving his consent to being monitored? I can't see everybody online, but if you raise your hand or begin talking, that'll be fine. Or do you want me to call on you? Will John prevail in this situation? We're talking about consent. Should logging on itself be consent? Does it have to be verbal consent? Does it have to be written consent? Gary, what do you think?
Well, I'm thinking it's they're logging on to the company computer and without knowing the policy of the company, excuse me, I would say that he or she would not prevail because it's not their computer, it's in the workplace. I think the employer, this is not my best guess, is free to monitor through their own equipment.
Okay, anybody else? James?
My understanding is that in your reading of the case, you indicated that the employer has, when the employee enters on the system, is told that they're accepting the monitoring by the employer. And once that's known, I don't think he has much of a chance to prevail.
Okay, anybody else before I respond? Okay, I think I'm going to hold my responses till I finish all 4 of the questions attached. Will employee John, on the issue of being monitored with screenshots, do you think that is a legitimate activity that would be allowed every 10 minutes? Christian?
I mean, I think so. Again, I think that the consent that has come with logging on and the fact that it is the employer's equipment, I think the employer has a reasonable expectation that work is being performed. So I don't think that there is necessarily an issue with a screenshot every 10 minutes. It might be a little excessive, but I don't know that it's problematic.
Okay. And should the company have access to his personal emails?
If they're done, oh, go ahead.
Oh, go ahead, James.
This is Eric, and I was about to say that
Okay.
if they're done on the employer's computer, particularly if they're done on the computer during work hours, then it's going to be fine for the employer to watch that, do something about it.
Okay, I don't see you, Eric, but let me respond. What about private financial information that he got from the computer? Is that also fair game as far as you're concerned?
I believe so. If it's the employer's computer and work time, then it's fair game.
Okay. Now, I'm going to respond to all 3 now that I've heard yours. Anybody else want to respond before I do? Okay. Well, first, the logging in is legitimate. If he knows that he's going to log in and he's consented to it by logging in, that is legitimate. The screen time is not. Screenshots are generally prohibited. These are one of the exceptions of the act, the Communications Privacy Act, that's considered excessive. And should the company have access to the personal email, Eric is right, in terms of reading an email. If the company owns the computer and has given the employee a mobile device, he has a right to read the email. Now, as far as the financial data is concerned, that is strictly prohibited. Again, these are exceptions to the Privacy Act, the Communications Privacy Act. That particular one is an exception to the rule, as is screenshots. Okay. Can the company monitor idle time status? Sandra? I can't hear you.
I didn't have my hand up.
Oh, okay. Well, anybody else can volunteer.
Yes, please.
Okay. Do you want to try that? Get a stab at it, James? Can the employer monitor idle time on a computer?
I would tend to say yes, because the employer always has the right to monitor what its employees are doing while they're on the payroll at their site. So I really don't see, unless there's some special statute that I'm unaware of that prohibits that.
Well, some that is debatable. Some idle time is allowed if it's not done through screenshots, for instance, every 10 minutes, because that's a legitimate, as far as management is concerned, the company feels that they need to protect their productivity, and therefore that comes within the realm of that. So some idle time is available. For instance, Time Doctor is one of the ones from I'm reading this pretty much from Harvard Business Review. That's considered a very fair practice. I mean, there are about 20 different monitoring devices, but they consider that to be more the fairest fair, because you have it's I guess a split between the employer's rights and the employee's rights. And so monitoring is allowed, but not through screenshots. Okay, let's start scenario number 2. Employee Marie Williams was employed as a clerk for Piggly Wiggly grocery store located in Columbus, Ohio. On the first day of the job, she was asked to sign a document consenting to be monitored. The monitoring device also had a video monitoring component. On May 18th, 2021, Marie was filmed on a hidden camera in her locker room, putting a stack of toilet paper in her locker. Later that day, a personal phone call came in from her ex-spouse that was recorded by the company, who supplied her with a mobile phone. The recording of the ex-spouse spoke of their recent divorce, custody issues involving the 3 school-age children, as well as her recent bout with COVID. On June 19th, 2021, the grocery store corporate officer had come to the office to show her the video involving the allegation of theft of supplies. Marie was then sent a letter of discharge. At the arbitration, Marie, through her union representative, argues that a motion to dismiss the charges should be had because the video was taken in a protected area, her locker room. In addition, the union representative presented Marie medical documentation submitted by email to Piggly Wiggly, diagnosing Marie with COVID, long COVID, with recurring issues involving chronic diarrhea, fatigue, and brain fog. Still further, the union advocate submits a receipt of a purchase of a 4-roll package of Charmin toilet tissue on May 16th, 2021. The first question, will employee Marie, by way of her union representative, prevail, and if so, why? Gary?
I'm gonna say yes. In the locker room, I've always understood the locker room to be off limits for video, simply because, not only because what you've described, but people may be changing clothes, things like that, personal stuff, and who's going to separate that out? So, and I think that's protected area per se. Now, if they suspect, I come out of the post service, if they suspect that there's criminal activity, such as theft, occurring via the locker room, the postal inspectors have videoed the person in the locker room while they were either opening the package or putting something in the locker that shouldn't be there. And that has been always accepted through arbitration. That is a legitimate use of the camera in the locker room.
Okay. I'm going to ask you another question. I'll answer at the end. The union representative also argued that a recording of Marie's ex-spouse was an invasion of Marie's privacy because it was a personal matter unrelated to a legitimate business purpose. What do you think? Someone else want to answer that question? Eric?
Sorry, what was the question again?
The conversation that the company overheard regarding Marie's ex-spouse, is that an invasion of privacy involving Marie, or was it a personal matter that was unrelated to a legitimate business purpose? Should the company have listened?
Well, no, I don't think so in that case. I mean, 'cause if I recall, it was on her personal cell phone as well, right? Or was it on a company phone?
Company phone.
Right.
Was it company phone?
Right. She had a right to use, right, the company phone. Yes.
Well, if it's on a company phone, that's a different story, but
Yeah.
Well, it is a company phone, but she had the right to use it. So when,
I think it's a private conversation and off limits.
who's talking now?
This is Eric.
Oh,
Eric
yeah,
Brown.
yeah. Okay. I remember you disappeared from the screen. Okay, anybody else wants to respond before we go to the next one?
I think that.
Where are you?
Linda.
Okay, Linda.
So I think what you're asking is, did she have a reasonable expectation of privacy in this type of phone call? And if she's allowed to use the phone for personal business on work time or off work time, I think when they understood what the conversation was about, they should have gotten out. So I would say a reasonable expectation of privacy.
Okay, I'm gonna wait to the end to respond, Linda.
I think
well,
I'm going to chime in here a little bit too. I think we would also want to take a look at the company's policies.
Thank you.
What is their policy
speaking
about
now?
This Ted Klecker?
Okay,
So we want to take a look at the company's policies and what has the company laid out in their policy about use of phones, electronic use of phones. So I think that's really going to dictate on having a good policy on what they cannot do.
okay. Will the company prevail on the issue of a viable receipt of the alleged purchase of the Charmin bathroom tissue?
So are you saying that are you asking whether or not she presented a winning defense with the receipt on the 4-pack of Charmin?
Right. In other words, did she Did she bring in the extra tissue because she had diarrhea because of COVID? Or did she actually make the purchase of the Charmin tissue and legitimate put it in the locker? Or did they have a right to go into the locker room for a video conference involving the locker and the allegation of theft? In other words, did the company have provocation, in spite of the fact that it may be an exception, to go in there because they suspected Maria of theft?
You could argue that the company was on notice that she had a particular issue that required additional toilet paper, if you might, however you want to say it.
Mhm.
So I'm going to say no.
Okay. And you want to respond, James?
Yeah, if she has a receipt for the exact number of toilet paper cartons at a reasonable price, really suspect that she'll be able to prevail on that. If she purchased it and brought it in.
Well, couldn't they see from the company's point of view if there's an absence of that particular number of Charmin toilet tissue as well? And what about the corresponding time period, if that matched?
Whether when she purchased it matched when it was
Matched, yeah.
being placed in the locker.
Yeah, I mean, I'm trying to be, yeah.
Good
All
point.
right, okay.
Yeah.
And last, okay, and the last one before I respond is, does the company have a right to video Maria in the locker room? I think somebody responded to that. Linda, did you respond to that earlier? No, it was Eric.
Yeah, and I say, no, the company cannot watch her in the locker room. The locker room is tantamount to a restroom, bathroom.
Okay. Well, those are all very good answers and pretty much on point. You are right. The locker room is generally off limits. However, because this situation involves theft, notice, as Linda pointed out, that the company might respond by saying, well, we were on notice of her alleged activities or theft, and that we realized that this was the number or of the brand that was indeed taken. And so if they have physical evidence that contradicts it, that will be the only reason they prevail. And the issue involving the spouse, one of you mentioned that they should not listen to the private conversation. I've forgotten who that was. Was that you, Eric? No, Linda. Okay. Well, you're right. Once now, and since the company owns the phone and it is a mobile phone and it is used for the employees' situations that might be of emergency status, once they overhear that it's a personal conversation, it is no longer considered a legitimate business purpose. That's right on target. And of course, the answer again comes from the exceptions that I mentioned in the Electronic Communications Privacy Act. So that's a pretty tricky one, but that's right on point. Okay, now scenario number 3, just like the others, I have questions about, and so let's go through that. Employee Bill Murray was employed as a nurse in a state-owned XYZ health clinic in Ohio. His primary duty was to administer COVID-19 vaccines. And most recently, the vaccine for monkeypox, now called Mpox, was in the process of being diagnosed. Bill was inoculated with COVID-19 twice with Moderna and twice with the booster. Recently, he exhibited pustule-like external bumps similar to Mpox. Upon discovery, he was summarily discharged without being tested, as the XYZ clinic maintained that he was a health risk to the public as their rationale for dismissal. Bill immediately offered to be tested and take the Mpox vaccine. However, due to the shortage of Mpox vaccine, it was impossible for the clinic to obtain them at that particular time. In addition, Bill reluctantly admits to having a genetic-based disease called Proteus syndrome that causes abnormal skin growth. Most importantly, Bill does not want to lose his nursing job. The overgrowth of skin caused by the disease results in a potential lifelong disability. At the arbitration, Bill, through his union representative, argues that XYZ Clinic violated the Health Insurance Portability and Accountability Act, often known as HIPAA, citing the invasion of privacy of his personal records, revealing the fact that he's a bisexual. Because the company has possession of his medical records, as well as concurrent violations of the Americans Disability Act, ADA. Okay, the first question. Will the union prevail and why?
Oh,
Yeah, Linda, you're a nurse, right?
well, so there's the HIPAA violation. There's the ADA discrimination. There's FMLA violation. So no, the union will prevail.
Okay. You jumped ahead of me. That was one of the
Oh,
next
sorry.
questions. That's okay. I knew you were a nurse and you would know that. Okay. Now, does the state have a superseding right to protect the public by allowing employees to be summarily discharged when it only appears that Bill had monkeypox? Eric?
Sure. I think that they do not have that overriding matter. Certainly, it's highly important and it would override many things. But in this case, they have no rational basis to believe he has monkeypox. They've seen something visually on his skin. They don't have any testing. They don't have a medical diagnosis from a doctor. And as a result, for them to conclude it's monkeypox and fire him for that is wrong.
Okay. Anybody else disagrees or want to chime in on this one?
I would like to say that they could have easily asked for him to go out on FMLA and have a return to work certificate from a physician. So this doesn't make any sense.
Okay. Now, what about a Title VII violation involving discrimination of sexual orientation, James?
I need to think about that.
Well, they talk about his bisexuality, you see, and does that come under the rubric of Title VII? And if so, why? Or why not? While you thinking, let me ask Sandra.
I'm not comfortable participating because I like to look at the statute in front of me, read it and consider it. And I don't feel as comfortable in the impromptu setting. I apologize, doctor.
Okay,
I'm not ready to answer. Thanks.
That's all right. Gary, do you have a feel about this? Whether or not Title VII violation would exist because of his sexual orientation and the fact that he that the company discovered he was bisexual?
I want to make sure I understand your question, but if the company finds out and that's all that happens, then, it's what they call no harm, no foul, I think. But if they find out that he's bisexual and they treat him different at that point, then there's a violation. That means say, no, I know you're a lady, and that doesn't mean I discriminate against you. Now, if I do something that obviously, let's say I put my arm around you or hug you unnecessarily,
Yeah.
I crossed that line. And so
Yeah, but what about the information that he is bisexual? Is that a HIPAA violation as far as you're concerned?
call HIPAA violation.
He didn't volunteer that
He
he was
didn't volunteer
bisexual.
that.
I mean, you can catch mpox when you're not. He didn't volunteer to the company, I am bisexual, right? So what about that?
See, I'm thinking about that, and I really don't know. I think
I don't know.
he's got been diagnosed with a disease, and I'm trying to see how that plays into a potential discrimination of because he's bisexual or did he get it? Because I don't think you get monkeypox just because you're bisexual. I think it hits everybody.
Well, okay,
So I'm going to say I feel strongly both ways.
okay. Eric?
Sure. I think that they're improperly gaining access to his medical records and calling from that the fact that he's bisexual is dead wrong. I think it's clearly a HIPAA violation, as well as at the way I read Title VII,
Right.
it would be a protected class.
Yeah.
And however, these days, it's hard to know what the law really is pertaining to Title VII with
Mhm.
the Supreme Court makeup and decisions changing the law.
Yeah, I understand. Now, what this Proteus syndrome seems to be a genetically based disease that's progressive. Do you think that belongs under ADA, Americans with Disability? Would that be would that fall under the rubric?
Wouldn't that also fall under Gina?
Well, I'm going to answer when everybody else finishes. But I
As
just
far
sort of
as-
wanted to get an idea of how some of the others felt before I respond.
As far as ADA, I believe that he would be protected.
Okay.
I think that it's meets the definition of disability under that law, and that they must accommodate.
Okay. And what if the company, what if Eric said to the company, I can use protective gear to continue my job and give out COVID exams and administer shots, in spite of the fact that you can't catch anything from me because it's a genetically based disease? Do you think that that's a legitimate position for him to have? And do you think that might be a viable response that he might get from the company? You're shaking your head, Eric.
Yes.
Okay, great. Anybody agrees or disagrees with that? What if his retort is, because of these pustular overgrowths in my body, I can't wear a long shirt or rubber gloves to administer, given the test, given the shot of COVID, but this is just something that happens once in a while when they break open, or, in other words, it's a temporary situation. Do you think the company then owes the employee the right to continue the job under those circumstances?
From what you're now describing, I think that the employer would be justified, not the employee. I think that the idea of having pustules that break open is problematic all by itself. And if he can't cover them, or not just conceal them from view, but also make sure that they don't transmit anything.
Well, if
I
it's
think he's
genetically
gonna
based, they can't transfer anything, right? Only
Well,
something that is communicable is transmissible.
Well, true, but I can't imagine, I guess in my own mind, and I could be wrong, a pustule that breaks open is genetic and doesn't transmit. When you say break open, I'm thinking that there's some kind of a liquid inside.
Yeah, well, I'm thinking it may be more progression of the disease. Does anybody else have anything else to say before I respond? Oh, Linda.
I think he would be, he should be offered a reasonable accommodation for the pustular situation
Because it's sporadic.
because it's sporadic.
Well, you know, because you're a nurse, you were right on point. And because you're a lawyer, you were correct about ADA. I think several people mentioned that it was covered by ADA. And it is. I mean, basically, I think the rule in ADA is whether it substantially limits one's major life activities. And of course, work is obviously a major life activity, right? So it would come under ADA because it deals with the employment and disability of discrimination in that arena. And it's a physical ailment. There's also something that, again, I think you, Linda, and one other person mentioned that HIPAA was protected. And here we're talking about health and medical information that for people who participate in employer-sponsored healthcare plan. And of course, it deals with privacy. So a company cannot say to an employee, what are you sick with? But they can require an employee to get a medical documentation from the doctor specifying when he's off, when he comes back to work. And then in the words of a doctor, they're protected. That is, a company would be protected to get that information. But what happens often is that we have what is known as unauthorized sharing of information by somebody in the company, or they ask others about a person's illness. So they call that PHI, which is health information. And I think Linda did mention that about the nursing thing. And I don't see him anymore, but Title VII does come under this particular case because it deals with sex. And of course, Title VII deals with race, color, religion, national origin, and sex. And so this responds to the discrimination of his status as a bisexual. So this is a pretty loaded one because that sort of put everything in the bag. Let me conclude with this. Employers have the right to monitor its employees. It is the general rule, but it does have some limitations as we discussed. For example, one cannot take screenshots or listen to private conversations. However, if the computer and mobile device are owned and is the property of the employer, you are allowed to hear conversations as well as monitoring emails. However, you can't collect collateral financial information and data from the personal files of an email. And of course, HIPAA laws prevent the usage of private health information to discriminate against employees. And Title VII protects employee discrimination, as does ADA. And of course, as we mentioned earlier, the definition for ADA protection is whether it substantially limits one's major life activities like working. So I want to thank you for inviting me. I think we have had a robust conversation. Sorry, more people didn't participate. And I'm really delighted with your involvement. I think that it's not whether someone loses or wins on cases, it's the thought process and the rationale as we frequently learn from law school. That's the big difference in winning and losing and individual situations. So thank you for being a delightful audience, and I appreciate your participation with me. We finished a little bit earlier, so if you have any other questions, this is the time to bring it to my attention. Ms.
I
Rath?
just want to say thank you.
Oh, thank you, Gary. I mean, everybody, I expected many more people, so I thought it would be a more robust conversation, but each one of you did participate, and I really appreciate that.
Are there any questions? Okay, well, if there's no questions, I want to thank you, Dr. McKissick, for this presentation. I want to remind the audience in and of itself that we are starting on January a academy on interest arbitration. It will be running on Fridays, but there's one exception for Thursday on January 26th. And we have a dynamic group of speakers. This is our fundraising event, so I ask that, if you all have the time, please register. I think it'll be very, very informative sessions. And our regularly scheduled Tuesday session will be on, I think it's our athletics or employees, part of a collective bargaining agreement, or athletes actually employees. I think that would be an interesting topical conversation as well. So please join us. We have our Christmas party on Friday. You're all welcome to come, interact, get together, network with one another, get to know each other better. And if I don't see you then, I want to wish you all a Merry Christmas. Happy holidays.
Hey, Meeta,
Yes, Gary.
the program you spoke about, is that 3 full days?
It's actually every Friday, except
Friday?
for the one exception on Thursday. I think that's on the 26th. It runs from 11 to 1. So it's 2-hour
okay.
session on Fridays, and it's all approved for CLEs. And this is the best way to get CLEs for the cost of $50 if you're a member, $125 if you're a non-member.
Okay.
Well, thank you very much.
All right.
Thank you
Merry
very much.
Christmas to everybody.
Yeah.
Good day,
Merry
everyone.
Christmas, Dr. McKissick.
Pardon?
I said Merry Christmas,
Oh,
Dr.
thank
McKissick.
you. Same to you, Gary.
Thank you.
Thank you very much.
Thanks.
Bye-bye, everyone.
Bye.
Bye.
Okay.